What's up, everybody? It's Wednesday night. Welcome back into LTL. Wow, what a crazy week. I feel like it's Friday already. Doesn't it feel kind of like Friday? I don't know. Maybe it has a lot to do with, now we look out the window at 7 o'clock at night and it's dark out. Now it's dark out. Like the summer flew by. Summer absolutely flew by. And now, like, what, in 3 weeks at 5 o'clock at night, it's gonna be dark outside. And then, in another month from that, at 3:30 p.m., the sun will start going down. It's crazy, but it has been a week chock full of lots of legal stuff and legal issues going on. Obviously, Karen was back in court down in Plymouth on Monday for her civil trial hearing, and it's just wild. It's wild that we're actually going to be here at this point and that the O'Keefes think that they're going to win. And I'm going to, everybody's talking about their First Amendment right. I'm going to express mine tonight when we go through this civil trial. I'll give you my commentary to it and my thoughts of what I think about all of this. But it's nice to see everybody here. Come on in, smash the like button. Let's get the chat rolling here. I was thinking about this the other day too. I went on a walk, right? And I don't know if you guys ever do this. You go out on a walk, you walk in your neighborhood, or you might be, a couple of blocks from home and you're walking. You ever walk by like one of those houses that just look really fucked up on the outside, and you're like staring at it and you're like, this house is fucked. Like, can you only imagine what it looks like on the inside? And I always thought, like, if I was to ever do that, I would have a really fucked up house on the outside, and then just in the inside, you walk inside and it's a palace, just to kind of like deter thieves or whatever, or like burglars. Like, just have a really fucked up house on the outside, and then you just walk in and it's like a 5-star hotel in there. I think that would trip people out. But do you know what I'm talking about? Like, you just walk down the street and like, or you're driving and you're like, that's a really fucked up house. That house looks fucked up. And you're like, can you only imagine what it looks like inside? So I don't know. This is stuff that I think about. I'm sure we have all had these thoughts before, but let's do this. Let me get up to the chat, see who's in here, and then we'll start rolling through the civil trial here. I'll give you kind of my thoughts on it. Let's see. Debbie is here. It's good to see you, Debbie. Cleopatra says, I hate that the summer, so sad that the summer's gone, right? And hello, welcome in, welcome in. LSAK says, I'm a winter gal, so let's bring it in. I hate the winter. I absolutely hate the winter. I hate the cold. I hate everything about it. But I sit here and go, I'm going to move. Fuck this. I'm going south. And I never do. I still stay here in New England. I still stay here. Just still feel like it's home. Jen says, what's up? Hello. Good to see you. Jermaine's in the house. Good to see you as well. Lori's here. We have Lauren DC. Nice to see you, Lauren. Channel moderator, friend. You know the biz. Lauren and I hang out offline. We're good friends. I love her. She's supporting me so well. It's done a lot for the show. Hung out on the show. We got Nan in the chat. Nan, good to see you again. Friend, channel moderator, member, lifetime friend. We do it all. We do it all. So it's really good. Nan's been up on the panel a million times. It's nice to see. Let's see. Yes, absolutely. I hate the winter. Angel says, Brian, talked about fucked up. I live 3 blocks from Rex Human's house, but I don't know how to spell his last name. It's close, and I don't know it off the top of my head. But if anybody doesn't know who Rex Human is the accused Long Island serial killer. I don't know why that case, like, I've tried to follow it when it first broke. No one was interested in that case. This guy is going to go down as one of the most prolific serial killers of all time. And I think I was reading today, there was some major blows in his case today. I have to go back and review it. And maybe if this starts kicking back up, we'll cover it here on LTL. But Kat says, I love the fall. I love the fall. I love this time of year. September is my favorite month. And the thing I like about September is most of the time, or some of the time, it mirrors March. So like March and September weather-wise are pretty close. But this September has been amazing. I hope we get more of this in October before it starts getting cold in like November and December. I hate the cold. Let's see. Carolinas will welcome you. Oh, yeah, I'd love to go to the Carolina. Yeah. Yeah, this case has completely stalled. I mean, they're saying what, 2027? It's ridiculous. And the thing that's crazy about it, Nan, is I look at it this way. As we sit there, and we're going to see at the very beginning of the civil hearing, they're going to pan the camera around the courtroom, and you have Jackson's reaction as he sits, Karen sitting there, and then you have on that opposite side, you have the O'Keefes, and you're literally sitting there and you're thinking to yourself, you guys just got whacked, your asses handed to you in 2 criminal trials, and now you're going to come back and try to win in the civil trial. You're going to get your ass handed to you again. You're going to be a 3-time loser. 3-time loser in this. And I can only imagine, like, you sitting there and you're actually going to go in through this, and the narrative that the O'Keefe's lawyer puts out there that, oh, Karen had done this, she concocted this, she hit John, left him. Did you not watch the criminal trial? She is factually, scientifically 100% innocent. It was proven she never hit John, and John never made any contact with her vehicle. Ever. It's set in stone, gavel down. Karen Reed is free. She never killed John O'Keefe. And now we're going to go into this bullshit, long, convoluted civil trial that's probably going to take forever. And their asses are going to get handed to them again. It's funny. When we were like halfway through the civil trial, and I'm sure Nan doesn't mind, I texted Nan and I was like, oh, this is going to be a shit show. And she's like, yup, period. She said, yup, period. And that's exactly what this is going to be. So it's crazy. It's crazy that they're going to, the O'Keefes are going to put on this facade. They're going to try to sue the Waterfall. They're going to try to sue McCarthy's. They're going to drag Karen back into this. I love the fact that Karen put out there, her lawyers put out there, and I know Nan talked about this on my show the other night, but, they put it out there for the public, and I think this was supposed to be done, and they could have done it through a filed motion before the civil hearing, but I think they wanted it to the public out there because the new cameras are going to be there. And it's a power play move that not only are they going to countersue, but they're also going to drag all the corrupt police officers that had everything to do with their dirty hands in this case. Oh, we're going to get the Mick Alberts involved in this as well, too. So I think it was like 8 to 10 people that are being dragged in as what being brought into this. So you're going to have Tully, Bukaki, you have Proctor, Brian and Nicole Albert, Matthew and Jennifer McCabe, Brian Higgins, the town of Canton, Canton Police Department, and they're also going to get brought into this suit. I keep saying dragged, but I'm just saying brought into the suit as well, too. So again, that now you're going to look at it. Is it going to be as a whole? Is it going to be as a group? Or are they going to be all sued individually? Crazy. It's crazy to figure this all out. I mean, this is going to be probably years, I'm guessing. Am I crazy to say this, Nan? 2 to 3 years? 2 to 3 years? What does everybody think? How long is this going to take? Put it in the chat. How many years do you think it's going to take for this to work its way out when the trial starts? Let me know what you think. Nan says 2 to 3 years. I think 2 to 3 years as well, too. I think it's going to take 2 to 3 years. Let's go up in the chat. Let's see here what we have. The Rocky Mountains hanging out. They get plenty of winter weather up there. And I've been through Montana before, and it is absolutely beautiful. I love the Midwest. I love it. I've driven through it. Wyoming, Montana. I've been to Utah before. I've driven through Colorado. If you haven't seen those states, and they literally have that whole like deer in the antelope play. I forget what song that's from, but you literally see that shit when you drive through like Wyoming and Montana. It's beautiful. If I was to ever have like rich enough to have a ranch, that's where I would go. I would be in like Wyoming or Montana, and I would enjoy it. I would enjoy it. Let's see. Tom, let's see. Hi, Tom. Great coverage. Yes, Tom was out there. Tom had all the video out there live. It was nice to see Tommy out there. I'm shocked that they even went to go down the Discovery Road that it's going to be a bitch. Good luck with that. And I can hear Tommy's voice in my head. Let's see. Nan says O'Keefe attorney does not believe in science like Plevin. The earth apparently isn't round. Yes. If you haven't seen that video, go check that out on my channel with Plevin. Denise says she agrees with me. Yeah, it's absolutely sham of a trial. Unredacted said 5 years, 2 to 3. We have 3 to 4. We have 3 if this doesn't get dropped. Not Haley saying at least 3 to 4 years. I mean, it's ridiculous. It's ridiculous. 5 years. We have 2 years. Born in Wyoming. That's awesome. Beautiful out there. You got to get out there. I've seen pretty much everything of the U.S. The only thing I haven't seen yet, which I have to go do, is the whole Pacific Northwest, and I haven't been to California yet. But everything else I've pretty much driven through. And I always like doing those maps. When they give you the map, it's like, what states have you been to? And you put all the you draw in like, oh, I've been to that state, and you put a little check mark or whatever. But I have not seen the Pacific Northwest. I want to get up to Washington State. I want to get to Oregon. And I want to get up there. I've never seen that part of the country, and I heard it's very beautiful out there. I have a friend of mine that lives out in Washington, and I've got to get out there sometime. I want to get to Idaho. I've never been to Idaho. I heard that's beautiful as well. So things I need to do on my bucket list. Things I need to do on my bucket list. San Diego, I've had friends that lived in San Diego. I never had the opportunity to go out there. I know Lauren, my friend, has been out there multiple times. And I've got to get out there as well, too. Haven't been out there. I haven't seen the Washington Peninsula. Arkansas, I've been through. I've driven through that. Yep. Idaho, that's awesome. Yeah, I want to sometime, Sue, I like this. I want to sometime just rent an RV and drive from Massachusetts all the way across and then take my time and come back. And maybe the first time we go up through the north and then come down through the south to come back home. I think that would be awesome. So let's see. Holly says, hello, Brian. I love the winter. Thanksgiving and Christmas are the best. Love the family. I absolutely love those holidays. I just fucking hate the snow. I hate cold and wet, and your feet, you just step out, you're in a puddle. It sucks. Absolutely sucks. So let's see. Yeah, that would be really cool, Tom. Nan's asking, can we travel the country with Tom? We should do it sometime. We should get an RV and literally just drive across, and we'll make like a trip. We could do like a book tour. I don't know. Anyway. All right, enough about that. Let's get into going over the civil trial hearing. It's just crazy. I think this is the whole thing is just messy. It's dumb. I think the O'Keefes are going to turn up to be, in my opinion, I'm expressing my First Amendment right. Everybody's doing this. They're all expressing their First Amendment rights. I'm going to express mine. I think they're going to be 3-time losers in this. 3 times losers in this, and we'll just have to remain to be seen, but it's ridiculous. Absolutely ridiculous. Let's see here. I want to read a quote from, okay, I'm reading this from NBC 10 Boston. Excuse me. It says, the lawyers for the O'Keefe family, on the other hand, said Reed caused them emotional distress by fabricating her own, quote, conspiracy about the events leading up to the 2022 death, launching a, quote, public campaign of disinformation and using crime bloggers to pit her massive following against them. Quote, these are real damages for real people who have suffered long enough. A lawyer representing the O'Keefe said in court. You know what I have to say with that? You guys decided to fucking align yourself with people that clearly know or clearly did something to your son. Clearly, in my opinion. Clearly. Okay? You decided to fucking align yourself with those people. And I've talked about this before. God forbid I ended up dead on someone's front lawn. Okay? And there was a shit ton of people in that house. I'm already going to tell you right now. The very first thing that my mother would do, and God bless my mom. My mom can't drive. She's legally blind. She would find someone to take her in a car and fucking drive over there the next day and do one of these. Hi, can anybody tell me what fucking happened here last night? That would be the first thing my mother would do. She would go to that house, knock on the door, and start saying, y'all got some explaining to do. I want to know everything. Not just lead it up to the people inside the house to fucking manipulate you and say, oh no, this is what happened. No. I would say, my mother would say, I got some questions. Someone needs some explaining to do here, because that's mother's intuition. It just kicks in. But you wanted to roll with the fucking assholes inside that house that wanted to cover this up and get all those dirty cops involved to just keep piling it on and work their way backwards. I know Todd talked about this before, taking the end result and working their way backwards to manipulate all of the evidence in this case. That's what happened here. That's what happened in this case. They had it. We had Proctor 16 hours in that had already made his mind up that Karen Reed was going to be the one that had done this. You can go, if you don't believe me, go back and watch. I have the body cam footage. Yuri's in on it too. Look how he was acting towards her on intake. They already were there inside that barracks on the day that she was rearrested and brought back. They were already formulating this plan. Pin it on the girl. Go back and watch the body cam footage. I have it. You can watch it on my channel if you haven't seen it. Just look under the tab, the Karen Reed body cam footage tab. Go back and start looking at it. But I'm sorry, my mom would be fucking knocking on that door and going, what happened here? Someone needs to let me know what happened here. Start explaining. I'm taking notes. That's how this is going to work. But anyway, I see a lot of people agreeing with me here in the chat. And the manipulation already started with Peggy hours into this from those fucking people inside that house. So I don't want to hear it. And if you're a 3-time loser, you're the only one to blame is yourself, because you wanted to roll with them. And you should have looked at the facts. All right, let's get into the civil trial. We'll pull this up. Alan Jackson sitting here like, fucking, here we go. Already the look on his face. Here we go. Bring it on. Bring it on. All right, here we go. Let me play this. I'll do something. Like, I'm ready to fucking mash these people in the ground again. Mash these people in the ground. I remember, and I can talk about this now because the trial's over, but I remember I was in the presence of Alan Jackson one time, and I said, who are you waiting to get there again? And he said, Jennifer fucking McCabe. I cannot wait to get her on the stand again. All right, let's.
Counsel, I asked the question that you asked, Counsel. He would like to do status first, then the Rule 12s, but he also said to me if you could check your calendars for trial date.
If you want to support the stream, you can. If you want to support the LTL platform, you can. There's a couple of ways that you can do that. You can go to the top of my chat right now, and there's a link that is there, and that will give you access to my Cash App or Venmo. Or you can do a super duper duper chat, and we can bring that up as well. Maybe you're feeling the same way I am. Maybe you got something to say. Maybe you want something highlighted, so you can super chat as well. Or you could support the channel by becoming a monthly member, and that supports the channel on a monthly basis. And I apologize, my members. I owe you a members only live soon, very, very soon. All right, let's keep playing here. I'm going to remind everybody right now, I am going to pause and commentate through this. If you want to watch this without my commentary, I have it on my channel. You can go there and play through this. But let's get into this. Let's hear it again. Let's go through it. Ridiculous.
All right.
Yeah, that's cringe. Super cringe. And that's like something I want to bring up too, is like when I heard that, I was kind of like, Yeah, they're going to try to spin like this whole emotional human element into it. And don't get me wrong, the death of John O'Keefe is fucking absolutely 1000% tragic, okay? But I can't believe that the family is going to sit with the motherfuckers that hold the key to the truth in this investigation. You're going to keep rolling with them. So you have, again, and I said this will be in my stream, you have no one but yourselves to blame when your ass gets handed to you 3 times. We've been through two criminal trials, and your ass is going to get handed to you in the civil trial as well, too. You're going to look like a bunch of fucking donkeys in the end. Absolutely look like a bunch of donkeys in the end. All right, here we go. Let's play. I already know. People are going to be like, you're swearing way too much on the replay. It's how I feel tonight, though. I don't care. My channel, my platform. Good Murphy, good to see them. Dennis Sweeney, good to see him. All right, let's speed up and get. Let's go here.
And all before the court is 2483 CV 692. This is the case of Paul O'Keefe and Alia versus C&C Hospitality, LLC, DBA, CF McCarthy. That case is called for status and for Rule 12 motions. Counsel, please introduce yourself for the record, beginning with plaintiff's counsel. And if you could state the party you represent as well, thank you.
Good afternoon, Your Honor. Attorney Mark Diller on behalf of the plaintiffs.
Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs.
Good afternoon. Good afternoon.
Good afternoon, Your Honor. Damon Seligson on behalf of the defendant, Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Charles Waters for defendant Karen Reed.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good afternoon.
Good afternoon,
Your Honor. Real quick, I just want to let everybody know what a Rule 12 motion is if they don't know. So let's see. A Rule 12 motion refers to procedural motion under Rule 12 for a federal rules of civil procedure or criminal procedure, which allows parties to raise concern, defense, and objections before or during a trial. I'll get this out. In a civil case, these motions typically seek dismissal of a complainant for reasons like lack of jurisdiction, improper venue, or failure to state a claim or a judgment on the pleadings. In a criminal case, Rule 12 motions are used to raise defense, objections, requests that can be resolved before a trial on its merits. So just want to do that for people that might not know what that is. I had to kind of look it up. So, all right, here we go.
Your Honor, Aaron Rosenberg, also on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. William Keppel on behalf of Karen Reed.
Got it. Okay.
Good afternoon, Your Honor. Christopher George on behalf of the defendant Karen Reed.
I met that attorney before. He's a very nice guy.
Good afternoon.
Good afternoon, Your Honor. David Hassett on behalf of Waterfall Bar and Grill.
Okay. I'm sorry, you say the Waterfall?
Waterfall, yes.
Thank you for becoming a new member. Appreciate that.
Good afternoon.
Good afternoon, Your Honor. Looking Rose on behalf of the defendant, CF McCarthy.
Good afternoon. Okay, that's all the counselors. Good afternoon, folks, and welcome everyone to the event for this afternoon. When I was assigned this case last spring, the first thing I wanted to do was try to get a sense of where we all are going to.
I'm going to say this too, and I like that later on you're going to hear, and I like that the judge says, look, you know, this is going to take a long time to go through, and no matter what amount of money may come out of this, it's never going to replace anybody. Like, it's almost kind of like a fair, like a warning. Like, look, you know, like whatever comes out of this is never going to replace someone. So, and he's like, all right, if you want to go forth, we can go forth. And then they set the date, but you're going to hear that later in the hearing. Here we go.
In our tracking order and get a sense of what direction this case is going. And in the meantime, it looks like there was a motion to dismiss filed by the defendant. So what I would like to do is go through some of the procedural issues that you see in the case for now. We can talk about tracking order. I do think that it's important to get a trial date established at this point, like we would do with any kind of a wrongful death tort action. So to that end, we'll start with the plaintiff. What do you see as procedural issues? I'd like to get an update on discovery and how that's all going. Counsel? And then we'll get into the motions to dismiss as a substantive issue. I know there's a lot of people here that want to see what the case is all about, but I think it's more important at least to get an idea procedurally where you stand.
Understood, Your Honor. Plaintiff has served all of the defendants with discovery. All of the defendants are currently late with regard to producing discovery. We have not received any as of yet, or minimal. We have started to get some of the documents from the DA's office, though we are is significantly deficient at this point. We're still waiting for the records to come in. So we undertook with the stay that we weren't able to get any information, and the DA's office wasn't turning anything over while the criminal matter was pending. So we're still trying to get all the documentation in.
Okay, but just if I can follow up on that, the stay that was issued, Judge White had issued one back in maybe the fall. I had issued one when the criminal trial was ongoing. That was sort of a self-defining 60-day or whichever comes first. So that should be pretty much in the rearview mirror for now, right?
I recognize that, Your Honor.
Right.
So when the stay was lifted, all discovery was served on the parties or thereabouts.
When you say discovery, we're talking about depositions, documents, notices of depositions, or no?
Only one deposition has been noticed, and it's been tabled because we don't have any documents.
Man, I should have just had you come up here and help walk through this with me tonight. I should have asked you to come up and hang out. You can let us know about all the civil stuff, but I know you're in the chat, you're typing.
At this stage.
I see. Okay. So it's really the paper discovery that you're looking for. And when you say the DA's office, that obviously is not the defendants, that's going in a different direction, but you're pursuing that sort of on your own?
Right, but we've also, I anticipate that the defendants have all the same data that was exchanged during the criminal matter, to which we haven't ever received. So we have requested that both from the defendant, and we've requested it from the DA's office.
Okay.
It is coming in from the DA's office in parts, and I anticipate we should have it all within the next 21 days, is my guess.
Okay.
In the interest of time, we're gonna.
All right. Procedural issues from the defendants. We can start with you, Attorney Seligson.
Thank you, Your Honor. As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy.
I like this because it's like, all right, you're going to drag my client into court, Karen Reed. Okay, the O'Keefes are going to drag my client, Karen Reed, into a civil litigation with McCarthy's and the Waterfall. So you're going to drive my client in. Oh, by the way, because you still want to sit with these motherfuckers that were there at 34 Fairview night. Oh, guess what? We're going to bring them in to the lawsuit as well. And then they just name all the individuals. And of course, they're going to go after Mass State Police, where we've talked multiple times on here. Nan, Todd, I've had Mazza on, among others, that we've talked about the violation of Karen Reed's civil rights from all those law enforcement agencies that had their hands in this. But I like the fact that they're getting that out here. They're saying it to the public. It's now out into the public. The public's going to know that, hey, if you're going to drag my client into civil litigation, the people that you want to roll with that were there at 34 Fairview that night and know what happened to former police officer John O'Keefe. Karen Reed's completely acquitted of all these charges. That scientifically and factually, she did not kill John O'Keefe at all. But if you guys want to sit there, the O'Keefes want to sit there with these people, that's fine. Bring it on. And we're just going to bring them into it. And then they have some explaining to do. Because now, and correct me if I'm wrong, and we have a legal mind that's in the chat, but civil, when I understand, civil, you get everything. You're not protected by most of the stuff that gets pushed out in a criminal case. Be a lot of depositions. There's going to be a lot of discovery, and you're going to have to open up your phones, your books, your house, whatever it may be, whatever they ask for. And that's from my understanding. In a civil case, you pretty much get everything. You can ask for it and get it. Yeah, that's pretty much. Nan says you get everything. So they better be ready for it. They better be ready for it. And everything's going to come out. You're going to hear more things that come out in this case that we never even heard in the criminal case because there was so much evidence suppression in that case. You're going to hear everything. So, all right, here we go.
Of Karen Reed's civil rights. And then a claim against the town of Canton through its police department for negligent failure to secure the garage and the sally port. We asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts. In order for us to fairly defend Ms. Reed in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in. To do that, we would be alleging that the individuals in the House diverted attention away from themselves towards Ms. Reed, that law enforcement then acting on that diverted attention away from her, because the people in the House were either police or police adjacent who were socially and personally connected. Then they collectively conspired to ensure that what happened in the House was not explored and investigated. And instead, Ms. Reed was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims.
The thing is, Karen has the biggest fucking leg to stand on right now with this claim that her lawyer is presenting right now. She has the biggest fucking leg to stand on because it's been proven. It's been proven. And I know I've said this a million times already through this live stream that she is factually innocent of not killing John O'Keefe. She's factually innocent. And this now, she has a major leg to stand on here. So it's like, all right, that's fine. You guys want to go into civil litigation. You want to sue her civilly, bring it on, because she's factually innocent of the criminal charges. And I think that's a big leg to stand on here in this trial.
We synthesize the process to bring these claims and parties in. What we're asking the court to consider is for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed, regardless of how the court decides those. We still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading. Serve all of those new parties with that complaint. Allow them 30 days, not the normal 20 days, to respond so the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention. And I'm happy to brief it so that Mr. Diller can have an opportunity.
Well, at a minimum, you're going to do that. I'm envisioning what the plaintiffs are going to say to this rather extraordinary process, but go ahead.
But that would be, otherwise it's going to be a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claim should be in this case. They all arrive out of the same facts. They're not separate. And that's essentially what we like to do. We like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there. Okay.
looking like they want to pull this all together into one trial, from what I'm understanding here. He's like, hey, it's not separate. Let's bring this all into one trial. But articles that I've read that this might be all heard separately. It's just how maybe the judge is going to see all this and how this all plays out. All right, let's hear more here.
All right, let's hear it then from the Waterfall.
Yes, Your Honor. We are in the process of completing written discovery propounded to us from the plaintiff order extension until next month. We anticipate that that will be completed then. We as well.
When you say an extension, this is an agreed to extension? Because the tracking order is what it is. We'll get to that in a little bit.
It's been agreed to.
Okay.
And then, Your Honor, we're looking at depositions, but we don't want to consider noticing depositions yet until a lot of the document requests have been answered and the subpoenas for keeper of records. We haven't seen any of the records. We're aware of them certainly from the criminal trial, but there are a lot of records, as I understand it, that are still to be produced, so that we would then proceed with depositions as warranted in conjunction with counsel and obviously picking dates that work for all. But that's what we foresee in the immediate future, Your Honor.
All right, thank you. Let's hear from C.F. McCarthy, then.
Your Honor, Governor, similar vote as to Waterfall, we were putting official touches on our discovery responses. The last leg of it is just communications from employees, United incidents, some of whom no longer work with C.F. McCarthy's, but we anticipate having that included in the very short term and getting that over to my brothers.
Okay. All right, thank you. Let's hear from the plaintiffs then, in terms of the response to the procedural issue that was raised, in particular by Ms. Reed's counsel. Are you aware of the circumstances that they're seeking to join 10 additional defendants into this action?
Absolutely not, Your
It's the
Honor.
first notice you've gotten?
Of course, I would
Not how the
expect
court
that.
system likes this stuff to work, folks.
I would expect the courtesy of the meet and confer, or at least let me know. Obviously, they can choose not to do so. That's their prerogative, but I certainly would have liked to have been made aware. Section 1980.
They wanted to put this out to the public, so the public knew, and it wasn't done through emotion. Let's do it today. Let's hit them hard. We're going to say, look, we're going to bring if you want to play ball, we're going to bring everybody into this, and we're going to let the public know we will not back down. This is a frivolous lawsuit. It's bullshit, and your ass is going to get handed to you 3 times over. 3 times over. That's basically what that statement is. All right, here we go.
3 actions, I believe, Your Honor, would have to go up through the federal court. We're not seeking to have this case removed in the federal court. We started in the state court. We're intending to move forward in the state court. We would like to have a state court, Plymouth jury decide this case. So to the extent that my brothers and sisters and all of those who are involved believe that they have other legal rights and they want to pursue other legal theories, that's their prerogative to do so. When it comes to interfering with our opportunity and right to justice, we're not looking to sideline that, Your Honor.
All right. Any response, counsel?
Thank you, Your Honor. We are asking for permission to serve a motion to advance this procedural proposal. So Mr. Diller is not being surprised by the argument that we're going to present to the court. He will have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact, this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against. This is not just a wrongful death action. Our narrative of what took place.
But it is, though. It's the plaintiffs. Well, just hear me out for a second. And when you say that it's not just a wrongful death, that's what the plaintiffs have alleged. The defendants have filed motions to dismiss portions of those. So this, at its essence, is a wrongful death action being brought by the plaintiffs, right? So what you're seeking to do is to be allowed to amend these proceedings and to effectively bring in 10 other defendants for the claims that the defendants have against those third parties that aren't noticed here, right? So you've got to procedurally give them notice as well as the plaintiffs notice of this event before it goes to any adjudication by the court.
And that's what we've built into this proposal, which is trying to streamline that process, not depriving them, the new parties, of the opportunity to argue both the procedure as well as the substance. And we're suggesting, instead of serving party X with a third party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case, and then brings another motion to dismiss substantively. We're not seeking to...
Isn't that what the rule requires?
The rule does require that, but the court has discretion to consider the streamlined approach. And we'd like to brief that for you, Your Honor, but we're raising it at the status conference so that, because we are scheduling deadlines and events out into the future, we'd like to at least have the opportunity to advance that argument for the court and allow Mr. Diller to respond to it. And then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor.
All right. So I don't know that this
Tommy says, so I got a question for Nan and Brian. Where are the female patrons when they knew they needed another female? Shame on those perverts. I think you're talking about the talking about her arrest, Tommy, and not having a female police officer out there. I think that's what you're talking about. Give me a heads up if that's what you're talking about. Yeah, they should have had a female there. Yeah, they should have had a female there. Absolutely. Yep. They brought the men on to intimidate her, to make her fold. And Karen, I mean, as you saw in the body cam footage, she fought back. You know, she fought back. She yelled back at them. Go Squad shirts. No, I don't. You know, the funny thing is, this is not a LTL shirt. I have to make some, and I'm thinking about making some of the Go Squad, like on my new avatar. I don't know if you can see it here. Oh, hang on. I want to make some like this, like with the ghost symbol there. So I've got to do that. And by the way, is everybody liking the new avatar? I kind of like it. It's cool. It's like a cartoon. All right. Anyway, let's get back to the hearing. Let me know in the chat if I should make some Go Squad. I need to make some new shirts. Definitely. 100%.
There's any ruling by the court today that would have to be made relative to that, because it isn't even filed yet, so that there's nothing before the court. So ideally, what my instructions to the clerk's office by setting this event up was to get a trial date from you folks and then work backwards, like we would do with any wrongful death tort action, which this case is. I take exception to the defendant's notion that this is not just a tort action. It is. That's what it is. It's a civil case. I know there's a lot of people who are interested in this case, but at its heart, there are at this time 8 parties involved in this case. Correct? There's 5 for the plaintiff, and there's 3 for the defendants, 2 corporations and Ms. Reed. So that's the way the case is shaping up. You've got your tracking order, so you understand what the deadlines are now. I have the tracking order, I think basically shows this case as having discovery. Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pre-trial conference February of 2027, with judgment by August 26th of 2027. So that's what the tracking order has in store as the case stands now, right? I mean, we could get you a trial date way sooner than that if you wanted to. I mean, literally, I could. The clerk and I were talking earlier before today's proceeding, and I may end up having to suspend, depending on what the circumstances. We were charging the jury on a homicide case earlier today. So we have a deliberating jury right now. So I don't know that I may have to suspend and then rejoin here in a little bit. But for now, so you understand it, we could get you a trial date as soon as practically this spring on this case. But to join 10 new defendants under wholly separate theories of people that haven't even been joined yet in this litigation puts that on its head. There's no way we could.
Like, Karen hasn't even had a break. She hasn't even had a break through all of this shit yet. You know, dragged through 2 trials, and it's like immediately, you know, what? It's been a couple months. You know, let's try like 4 months, and you drag back into a fucking courtroom again. It's crazy. Crazy, crazy, crazy. No break. And here we are. Now this is gonna supposedly run until 2027. I think 2 to 3 years. It's gonna run longer than that. All right, here we go.
Even have this procedural process outlined by the spring, most likely.
I understand that, and that's the dilemma that we're trying to bring to the court's attention, because there is going to be an affirmative pursuit.
Well, you're saying you said earlier affirmative defense in this case, which those would not be affirmative defenses. Those are wholly separate third-party causes of action against people who are not part of this litigation.
Oh, yeah, 100%.
So it's not an affirmative defense. It's not an affirmative defense in the traditional sense, but it is part of the defense in the face of the wrongful death claims. The wrongful death claims stem from the same facts that the affirmative claims would be seeking to be pursued against. So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reed is the plaintiff and these parties that I've identified are the defendants, we would be pursuing down 2 separate pieces of behemoth litigation when we can consolidate them at the same time. That's what we're trying to suggest may be a more streamlined approach. It's not intended to delay. It's actually intended to try and synthesize the process and conserve resources, attain judicial economy without prejudicing the plaintiff. Discovery is already ongoing. But you have 2 depositions, for example, of parties in 2 separate cases, where we can have one and the claims could proceed at the same time. Just seems to make judicial sense. That's why we're raising it. We'd like to brief it if the court gives us that permission.
Okay. All right. On that last discrete issue, anything else from the plaintiffs?
We have served them with discovery, asking them, they have a burden if they're going to do affirmative defenses to establish that there are third parties who are responsible here. That can be their affirmative defense, but they have a burden to prove that. And if they can't meet that burden, then it should never come into our case. If they're seeking to overlap these two cases and throw it as far wide ranging as they just announced, then there's no way that we would not be prejudiced by their strategy in the plaintiff's underlying case.
All right, those issues are reserved. I'm certainly not going to make any ruling on that. There's nothing formally before the court, no written motion, no Rule 9A or 9C certificate, none of that stuff. So it's not procedurally before the court, but certainly I appreciate hearing the argument nonetheless that this may be the future landscape of the case. What also brings us here, when I noticed the status conference for today, the defendants have filed motions to dismiss. If you're prepared, I'll go forward on that, let you deal with the substance of the motions to dismiss. I have read through your material, so I get the gist of what the defendants are raising. Counsel, would you like to proceed?
Thank you, Your Honor. As we've briefed, Your Honor, the counts that are at issue in the motion to dismiss are counts 13, excuse me, the counts 10 through 13. They are infliction of emotional distress claims. As we have presented in our papers, none of the plaintiffs observed the alleged incident that is described in the complaint. None of the plaintiffs came upon the decedent in close enough proximity to state a claim for emotional distress. There is no...
Talking about the children.
The cases, Your Honor, limit when a claimant can claim emotional distress.
You know what the PTSD was? The PTSD was making those children go in there and fucking testify during the trials. That was the PTSD, that you brought them in and fucking used them in the criminal trial. And now you're trying to use them in this civil trial and say, oh, well, you know, they have emotional distress. And I'm sure they do. I'm sure they do from this whole situation. But to keep dragging them back in to all these courtrooms at such a young age, and we talked about this before, what kind of impression does that leave on a child when they're brought into situations like this? It's just trauma over and living it over and over and over again. These kids will be in psychological evaluations for the rest of their life. They'll be counseling for the rest of their lives, where after the criminal trial, they could have gotten the appropriate help and started to heal and move on with their lives. But now it's like, oh no, let's drag them back in and use them as an excuse in this civil trial. That's what we're going to do. And I don't want to state their names. I don't want to talk. I don't want to put the kids' names out there. You all know their names. Okay. I don't want to say their names, but it's like you're using these children as your crutch, as the major sticking point, and you're going to hear it in this hearing of the civil lawsuit. All right, here we go.
The cases talk about temporal, spatial, and relational limitations. Taking the claim that Kaylee Furbush has alleged, that claim is for negligence / reckless / intentional infliction of emotional distress. And the basis of that claim is that there was a discussion on the telephone, or discussion after Karen Reed had left 34 Fairview in Canton and had somehow started to fabricate a story about what had taken place. Kaylee Furbush was not at the scene, and the perception of someone dying is not an actionable claim under any case that we can find in Massachusetts state law. So she wasn't at the scene, didn't come upon the decedent, and therefore doesn't have the same types of proof, at least is played in the complaint, that would satisfy the limitations that the case law sets up, the temporal, the spatial, and the relational. With respect to the claims of emotional distress that have been brought by John O'Keefe's mother, father, and brother, again, they were not witnesses to the event. They came upon him many hours later. There are cases, and particularly the Cohen case that is cited in our brief, that speaks to the time that passes between an alleged event and when a family member or a bystander witnesses the consequences of that alleged event. And in that Cohen case, the court speaks to the fact that the mother of a young man that died in a plane crash didn't get to find out about it until many, many, many hours later, and the court denied the the right to pursue an emotional distress claim. More importantly, Your Honor, there is a remedy here. If for the sake of argument, there is a remedy here through the wrongful death statute. And the wrongful death statute compensates for the types of harms that are alleged in the complaint. So what we're asking the court to do is to dismiss out the emotional distress claims because they are duplicative and allow the plaintiffs to pursue the wrongful death action singularly. We rest on our papers. Thank you, Judge.
Right, thank you. So let's turn to the other defendants if they want to be heard. You've filed separate motions, essentially arguing the same relief, but if you have anything you want to add, you certainly can. Waterfall?
Yes, Your Honor, we have Waterfall, just very briefly. I think the distinction here the council's making is that these claims, these infliction of emotional distress claims are intended when you're in the zone of danger or you're a recipient witness. And in this instance, it's many, many hours later that the parents are seeing the decedent in the hospital. I think it's after 7:50 a.m. And so based on what the Cohen case states and in terms of the principles that the courts have applied here, it just isn't from a relational standpoint close enough in proximity to be able to advance this type of claim. And in terms of the wrongful death statute, those loss of consortium damages, the damages of the loss of a son, if the plaintiff is making this claim going forward, are in fact addressed in that statute and obviously would be available as remedies to the plaintiff.
What about Semino versus Milford Keg Incorporated? I have a 1982 case that I found talking about the wrongful death, emotional distress injuries. Have you reviewed that case? I'll give this case site, 385 Mass 323. It's a 1982 case. It would seem to suggest that that emotional distress is really not preempted by the wrongful death statute.
Your Honor, I think the wrongful death statute alone would not necessarily cover all of the damages, but my argument would be more in line with the argument that in terms of where they are in relationship to the accident, since it wasn't witnessed, and since it wasn't immediately thereafter that they came upon the scene in a roadway, in a driveway, and observed the decedent, I would argue, Your Honor, based on that, that that's a problem for the plaintiff moving forward, and that would be the court's consideration. I appreciate, Your Honor, that there are some differences in the wrongful death statute and emotional distress claims.
Okay, thank you. Ferreter versus Daniel O'Connell's sons, a case that goes back to 1980, also kind of speaks to that issue too. Let's hear from C.F. McCarthy's on that. Anything else to add on the motions to dismiss?
Look at this, South Africa in the house. I've been following Brian's from South Africa, and there was a sudden split from the clan. So I'm going to see Brian. I'm going to see Brian cover the Karen Reed ongoings again. Yeah, I've been here doing my thing, doing my channel. That's what we do. Okay, let's keep going.
All right, great. All right, I'll take that issue under advisement. I do have some, I'll read through your briefs a little more closely.
Allow us to.
Yeah, of course. What I was going to say is that what will happen in just a few moments, I'm going to give the plaintiff an opportunity to respond to that. But I want everyone who's sitting here to understand that the comments I'm making now are not really doing other than just trying to tease out what the issues are. Motions to dismiss are not based upon the evidence, but rather on the allegations that are contained in the complaint. And those allegations, for purposes of a motion to dismiss, have to be accepted as true. And the question is whether or not the plaintiffs have stated a plausible claim under the case law, Iachino and others that deal with this issue.
Who does everybody think flips first? I like this, Teresa. Good question to bring this up. Who flips first? I think it's Higgins. I mean, judging by what he did in trial 1, I think that guy's going to flippy flop. Look at everybody says Higgins. I think it's Higgins. Higgins, who do you all think? Leave it in the chat. Let us know. Let us know who in the chat thinks will be the first to flip. All right, let's go here.
So with that context, plaintiff, if you want to respond to both the motions to dismiss raised by, I should say, both the two corporate defendants and Ms. Reed.
I do, Your Honor. Thank you. The question that's really posed for this court is, like you just said, assuming all facts are true, indulging every inference in the plaintiff's favor. Does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief? The answer is yes. This is a motion to dismiss. The lower standard, the Brum case, plaintiff's obstacle is a minimal hurdle, a relatively light burden, so long as the court looks at the allegations holistically. If relief to the plaintiff is plausible, by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one. There are 3 arguments that my brothers have put forward in this case. We oppose all 3 of them as follows. Number 1, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number 2, Your Honor, The defendants improperly seek to limit the scope of NIED claims by creating an arbitrary bright line test for such cases. Number 3, Your Honor, the defendants failed to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous.
Yeah, I love how he tries to put on the record, like he's going to try to put this on the record, like, oh, Karen did this. She conspired to do it. She had a plan. You're going to love all this shit. When she's literally, like I said at the beginning, you know, we all know Karen literally was factually innocent in both trials, has been proven scientifically, factually innocent, and he's going to roll through with, no, she did it. She hit him. She left him, you know, in the snow to die. You're going to hear all that shit. Hilarious.
In violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today. Throughout, we intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and nephew. JJ no longer has a voice. His life was wrongfully taken on January 29th, 2022. He lived a life of service. He was a Boston police officer, and his personal life, when JJ's older sister and brother-in-law tragically passed 2 months apart from each other, leaving 2 young children orphaned, JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them. Fast forward to 2022, Your Honor, JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. And Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost 2 parents tragically. And 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost 2 parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's.
I can tell you this. You all need to go subscribe to Leroy Truth Investigates. He does a lot of calling out corrupt public officials. He does First Amendment audits. He's been on the channel. He's such a great guy. I mean, I've met Leroy once, and we've had multiple phone conversations. He's been on my show, and he is one of the nicest people that I've ever met that I haven't even known for a long period of time. Now, I've been very vocal here, and we're working to getting some answers. I've been facing a health issue lately, and Friday I'm actually going to a specialist that's going to hopefully give me some more answers, and I need some prayers for Friday. But Leroy literally texts me every couple of days. He doesn't even know me that well, and this is how nice this guy is. He texts me every couple of days and asks me, how are you doing? Do you have any updates on your health? What's going on? I mean, it's amazing some of the people that life will put us in touch with. There are good people out there. There are good people that have good intentions, that care about you. And it's amazing. I mean, I've been blessed with so many good people in my life. And those people are people that are true friends. The people that you have to constantly reach out to and constantly have to call or text message, and they never reciprocate that, Those people are not your friends. Okay, they're not your friends. But people that have reciprocation in a a friendship or a relationship, those are the people that care about you. And I have learned a lot of that over the last 3 months. I had a lot of epiphanies come to me, and I went, oh, okay. Those are the people that really care. Those are the people that are really my friends. Those are the people that really want to be around me. So that dude is amazing. And please go sub to his channel. He's got a fucking awesome channel. And I'm hoping that someday our worlds will collide again and we can create some content together. I know we're meaning to do that. Another great dude too, Sean from Long Island Audit. Barely even knew me from anywhere. I hear from him every now and then. He updates me with stuff. Such a nice guy, but cool, very cool people. And you know all the people that I roll with here too. So Beach Life, thank you so much. And I appreciate all the prayers in the chat. I have an appointment on Friday, and hopefully we start getting to some answers here. So anyway, let's roll through the rest of the hearing here, about halfway through. And I love all you guys. I appreciate it. Nan, I love you. You know that. We talk all the time. I love you to death. And thank you. Let's see. Leroy says, Brian, thank you so much for your kind words. You're a very good man, and I feel very honored and grateful to call you my friend. Me too, man. You're such a great guy, and I'm looking forward to, once I get past on the other side of this answers to my health, we're gonna get out. I'm gonna come out to Jersey. We're gonna make some content, and we will collaborate. I want to do that. So, but please go subscribe to Leroy Truth Investigates. He's killing it over there. He has a great channel. Such a super nice guy, stand-up guy, very knowledgeable about things he does. Lots of great First Amendment audit content over there. And I love it. I love watching the channel. And this guy checks in with me every couple of days. I think I just got a text message from when was the last time you texted me, Leroy? Like yesterday? Let's see. Leroy texted me. He texted me today. He dropped a little video for me, but he checked in on me on yesterday, Friday. So nice. It's great. It's a great dude. All right, here we go. Karen Reed civil trial. Let's play this.
Injured body is now found right where Karen left him, buried in the snow. 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness at around 6 a.m. They rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public.
Enter the chat, Turtle Boy, right? Turtle Boy enters the chat. Oh, man. And this is where I was wondering, too. I'm like, are they going to try to drag him into this? And I don't know. I was asking Nan about this the other day, and she kind of gave, her feedback to this. But what do you all think? You think they're going to try to drag Aiden into this whole civil thing? Why? Because he wrote some stories and talked about the case and brought light to it. They're all pissed off about it because he brought the truth. He brought the truth to light. He shined light on this case and brought it to the forefront. And it just, it spiraled. And then good people got involved. All these great panels and channels that picked up this case. And believe me, for a long time, all those mainstream media was so afraid to cover this. They would not talk about it. We saw, Court TV, the way they leaned. And then once all this stuff started coming out, they started changing their mind. But we all knew from the beginning. You had Young Jerks, you had the Glare, Nurse Kim and Auntie Deb came in later, Melanie Little, Mark Betterow jumped on board, Nan, and I can go on and on and on. Aiden, of course, Tommy CPU with Boston Mike, and just, you know, all these channels, Broke Baker, you know, and I'm just rattling off channels here that are coming to mind really quick. And I apologize if I left anybody out. JFK show, you know, they all jumped in and we talked for a long time because we saw through all the bullshit right away. We knew it. We knew it. We knew it. We knew it. We knew it right away. When you, I mean, how can you not look at that first probable cause affidavit and go, wait a minute, something doesn't add up here? I mean, when I read through that the first time through, when I did a live stream about this, I was just like, what? This doesn't make sense at all, at all. And again, you know, there was dozens and dozens of channels that did good work on this, you know, that has been kind of in this circle. So, and they haven't let up. You know, it's only got more powerful. The channels have grown. More information is out there. There's great topical discussions about it, and it always will be. There's never, ever going to be another case like this ever again. I mean, this is going to set a mark in the history books of law. I mean, this will be dissected and talked about forever and ever and ever. There's a lot of great channels that did work out there, that did great work, you know, kind of in the circle of, you know, Free Karen Read supporters. And then all the people on the ground that did great work, in the Roccos for you know, campaigning and fundraising, and everybody, that every little thing that people did was just such an amazing thing. And the people that stood out countless times at the hearings and the court hearings, the trials, you know, on the weekend, giving up their Sundays to go stand out with a sign on a corner to let people know and you know, make people aware of what was going on here in the state of Massachusetts. You've got to commend all of those people. You know, they've all been part of it. And, you know, people continue to support, and it's great. I think it's really, really great. So, all right, I will keep going on here. Here we go.
Information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages
all the way
are duplicative of the wrongful death statute. We reject that argument. JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law. You have pointed out the Cimino case, where, let me just point out first, the wrongful death statute, it has two components for damages. It has two buckets of damages. It has the estate's damages. Those all are JJ's damages, his conscious pain and suffering, the medical bills, things that relate to his damage.
I'm sorry. I listen, and no, absolutely zero disrespect to John O'Keefe, but the whole like JJ thing, it just makes my spine turn to glass. I cringe. Like, come on, just call him by his proper name. You know, let's do it right here. If you're gonna represent, please just give the guy some respect and call him by his proper name.
Damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages. The lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Cimino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for over-serving him. The father brings two separate causes of action, one for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress, as the concept has evolved in the Commonwealth, is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the Cimino case, Your Honor. Cimino still remains good law. You were right to point that out. It directly contradicts everything that my brothers just argued here in this court. And I see no reason why this court should overturn the good standing law that exists under the Cimino. We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. That the law does not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident, because let's look at the law itself. The liability for NIED depends on a number of factors: where, when, and how the injury enters into the consciousness of the plaintiffs. And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness. It is misplaced for the defendants to suggest that it matters that plaintiffs were not at the scene of the accident. Because as you pointed out, the Farrader case stands in the exact opposite, where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress.
Yeah, I mean, I'm frustrated. I know I've dropped a million F words tonight. I'm so frustrated. And this is where, like, I think the O'Keefes had the opportunity to turn this around. Excuse me. I'm still dealing with that freaking cold that's going around. This is, you had the opportunity. You had literally your ass handed to you in 2 criminal trials. Okay. You wanted, like I said, you wanted to roll with the McAlberts. You wanted to roll with the corrupt police departments. Okay. That's where you wanted to roll in this. You could have turned around and said, you know what? She didn't do it. Factually, she didn't do it. Scientifically, they proved they didn't do it. Well, let's do this. Let's turn around and sue all those motherfuckers that were in that house that night. Let's see all the discovery that comes out of their phones. Let's hear all the things that went on inside that house that night. Let's see all the text messages. Let's see all the communication. If you had any real balls, that's what you should have done. Turn around and said, you know what? Now you have to answer for this. And maybe that would have opened up some more things. Maybe that would have opened up some more evidence and discovery. And I still think the FBI is still looking in on this. Maybe the FBI goes, all right, let's continue to dig a little bit deeper now that we have more information. But that's what the O'Keefe should have turned around and did. Okay, Karen's been cleared, factually innocent, scientifically proven. Now let's go after all of them inside the house. They're responsible. They have to ask questions. I know, like I said in the very beginning of the stream, what would my mother do? My mother would be down there in the very beginning of the next morning, knocking on the door going, what the fuck happened to my child here last night? Even though I'm a grown man, but that's what she would say. And say, you guys all have to answer for this. I have questions and I want answers. All right, here we go. Let's keep playing.
A shock, then a plaintiff who rushes to the hospital, so long as the shock follows closely on the heels of. It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness of the people that we're bringing those cases for. It's 12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She knows she struck him. She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship.
Actually, the people that the people that are responsible for hiding the injury are what? The people inside 34 Fairview. Again, I'm going to go back and say this. Karen was cleared, acquitted of any criminal wrongdoing with John O'Keefe's death, scientifically and factually. So this is, like Nan was saying, a fucking weak ass argument. Absolutely weak. Absolutely 100% weak.
To what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliore case, which has no relevance because it deals with somebody who has no close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected, and the son of the woman who brought the claim knew about her own, his brother's death. The mother.
Question for Nan. We'll pull this up. Josie says, question, Nan, do the O'Keefes have to pay for their own experts, or can they use the reports from the Blue Man Group, etc., that the Commonwealth used? That's actually a really good question. And we'll wait for Nan to answer that, and I'll pull her Nancer. I'll pull her Nancer up. All right.
Is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone. Does not experience the injury and never sees the body. Contrast that with everything that we talked about, Your Honor, where as soon as it was knowable, they learned about it, they rushed to the hospital, they saw the body, and they saw the body within minutes of him being declared dead. The purpose of the law is to distinguish between emotional distress from perceiving an injury versus the expected anguish that any person would feel from the death of a loved one.
All right, we have an answer. We have an answer. So Nan says, yes, the O'Keefes have to pay for their own experts. They can use the same experts, but they have to pay them to bring them to court. There you go. There's your answer. And look at this. We have a pop-in from the great Mazza Media. And if you haven't, and I know everybody in here probably has, you need to go over and subscribe to that gentleman's channel. And I will, and Mazza's been up here plenty of times. It's done lots of live streams with me. We're going to have to do something again soon, Mazza. But I will drop his link in the chat for the replay. And that's another great channel that you're going to want to follow. He does a lot of fundraisers over there. He just had a Kelsey Fitzsimmons, Turtle Boy, and Mike from the Young Jerks kind of combined fundraiser. And I think he raised over like $2,000 between everybody the other day. That's pretty damn good. So he's the power fundraiser, and go subscribe to his channel. So please. And we'll have to get Mazza up here again soon on the panel. The Nancer. Yes, we've now coined a new phrase in the chat. The Nancer. We need a Nancer on this one. I love that. I think that's great. Let's see. Question: are they allowed to say this even if she's been acquitted? Yes, because this is a separate trial. This is a separate thing. So, yep, they can fabricate their own fucking story around this. That's how it works. Yep. Let's see. Mazza said 2,300 plus 1,000 for Kelsey. That's great, man. Good stuff. I love the Nancers. Yeah, we need an answer. You do need an answer. That's a great phrase we coined here tonight. I love it. Oh, that's so good. All right, let's keep going through here and listen to this fucker lie some more.
I want to talk briefly about Haley and her NIED claim. To suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure, the third that she has now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own two eyes, I refer you also to the Cohen case, which they cite for different reasons, but in it, the language talks about sensory perceptions. To suggest that you can't use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all the time. And when it enters into our consciousness, it's hard to undo of it. It is very different from learning that your close family member has died. That is upsetting. It will be upsetting to anybody. But to have experienced the event or the injury and enters into your consciousness, that is the very reason and the foundation why NIED exists as a claim.
Yeah, you know what's even more traumatizing is that you keep dragging them through it. You're dragging them through it. You're trying, and we talked about this before. You're traumatizing those children, and I call them kids because a lot younger than me, and they actually still are kids. But you're dragging these kids through. You know, 2 criminal trials now. It's like, okay, we're going to do the civil trial. Let's bring the kids back into it. Don't give them any healing time. No healing time. No time to grieve. No time to heal. Get them right back in there because we need the money train. We need the money train now. So we're going to need you to step in there again for us and go up there and re-traumatize yourself. These kids will be in therapy for their entire lives. And only God hopes that none of this steers them in an awful direction that I would never want to see these kids go down into. Drugs, alcohol, crime. I mean, you are taking part of affecting their brains at the age that your brain is growing, what's the words I'm looking for? Is absorbing all this information, and your brain's going through this huge growth spurt right now. This is where you start to formulate, you know, your personality, your ideas, your views on the world, and you are now creating this huge impression on them and not allowing them to heal through this trauma. And this is just reliving it and playing it over and over and over again. A lot of people went through this shit with like 9/11. Where, you know, 9/11 happened, and what the fuck did they do? For like 8 months, they kept playing the same traumatic, you know, the planes hitting the towers and the towers falling. You just saw that over and over and over and over and over and over again. It's like, okay, like I've had enough. And that has made huge impressions on people. Like total PTSD have really messed up a lot of people. Messed up a lot of people, traumatized them, you know, to not want to get on planes again, go inside Todd buildings, go to New York. A lot of people moved out of the city. I mean, this is what this does. You're just reliving it over and over again, and you're not getting the proper healing from it. And I don't want to see these kids go through a bad stretch, you know, drugs, those coping things that people go towards, alcohol, drugs. I don't want to see that. Let these kids heal. Anyway, enough of my ranting. I hope you all agree. Let's go.
So on that second, we also suggest that you should deny it because they experience the injuries closely on the heels of them being knowable and perceivable to anybody. Third, Your Honor, the defendants argue that the intentional/reckless infliction of emotional distress claim should fail because there's no extreme or outrageous conduct directed towards the plaintiff. When viewed holistically,
go over and check out the JFK show. Check out his channel as well. JFK was up the other night with me, and I'd love to have a great conversation. Bring Kevin, James Jackson, JFK. We can chop it up and talk about a couple of things, but go check out Kev's channel as well. He says, I believe there will be more things that will come to light that we weren't even aware of. I 1000% agree with you, dude. 1000% agree with you. All right, here we go.
The facts demonstrate that Ms. Reed should have known her extreme and outrageous conduct would be detrimental to these vulnerable plaintiffs. And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be directed immediately towards those plaintiffs. As long as she should have known that the emotional distress was the likely result of her conduct, that's sufficient under the reckless infliction of emotional distress standard. So how do we evaluate what is extreme and outrageous? It's fact intensive, but the law does recognize.
Turn around and countersue the O'Keefes for putting them through this. And I hope they have a legal mind someday or legal sense in all this when this all falls apart and Karen walks out of this trial victorious as well too. I hope someday that someone turns to these children once they're, adults or whatever it is, and they realize all the trauma that they suffered because of all these incidents, being dragged through years and years of all this trauma, that they turn around and sue the fucking shit out of the O'Keefes. Get them back. Turn on them and sue them and say the emotional distress that you put me through. I'd love to see that. I'd love to see that. And of course, I'm just expressing my First Amendment right tonight, just like everybody has been doing lately. So all my thoughts are alleged First Amendment, whatever you want to say, free speech. But here we go. I mean,
that some critically important factors that need to be considered when evaluating what is extreme and outrageous. Plaintiff's susceptibility, defendant's knowledge of that susceptibility, and the relationship between defendant and plaintiff. The case law all suggests that gives rise to extreme and outrageous conduct. In evaluating whether defendant's conduct was extreme and outrageous, the courts should consider whether individuals at whom conduct is directed is known to be particularly susceptible to infliction of emotional distress. Boyle versus Wenk, 1979 case we cited to, Your Honor. Our case law has recognized susceptibilities to evaluate extreme and outrageous conduct to be a recent hospitalization in the Boyle case, a cancer patient in the Harrison case, elderly or frail people in the Bailey case, or children, minors, based on their age in the Sarkonis case, all that we've cited to, Your Honor, and I'm happy to give you cites. The law in Roman versus Trustees of Tufts College says, as it relates to this, the court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. The relationship of a plaintiff to the defendant and her knowledge of the plaintiff's sensitivities is an important consideration in determining whether the challenge conduct satisfies the extreme and outrageous conduct. That's the Russell case. Let's talk about Kaylee as it relates to the infliction of emotional distress. Should defendant Karen Reed have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Those are the questions that ultimately we pose to a jury. Kaylee was young, 14 years old. The defendant had a relationship with
that they are putting these kids through right there. They are putting these kids through. Those two people right there. Those two individuals right there. Lauren says John has been rolling in his grave about what they've done to Karen and those kids. Yeah, it's crazy. It's literally crazy. I'm sure. I am sure. Here we go.
Knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically. The defendant assumed the pseudo-parental role with Kaylee for nearly up to 2 years. The defendant, Ms. Reed, knows that she knocked JJ down. It's the middle of the night. She wakes up Kaylee abruptly. She talks about JJ being dead, being struck by a plow, being struck by a vehicle. Mind you, this is all hours before anybody has even discovered his body, and she is now actively talking about him being dead. Then, after creating this chaotic, upsetting situation in this young, fragile girl's psyche, she leaves her. She leaves her home alone, shocked and frightened. Compound that by defendant's choice to speak her false narrative publicly, to use social media, to leak public information through Turtle Boy, to control that narrative. Why is Turtle Boy out there saying the O'Keefe's family period of grief has expired and they are now fair game? Who leaked the autopsy photos that got published by Turtle Boy for this vulnerable family to have to be exposed to that they weren't seeing before? To the extent that the defendant argues that this is not extreme and outrageous, remember the law. It is the jury's role to decide.
Journalist. He's a journalist, and a source came forward and gave him autopsy photos. He can write about that. He can show it. A source gave me this, XYZ. You're allowed to do that.
Whether the defendant's conduct was rude and clumsy or extreme and outrageous. That comes right from the case law. As it relates to the family, Your Honor, should the defendant, Karen Reed, have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Again, those are the questions posed for a jury ultimately. But the law says conduct which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. Margaret and John have now buried 2 children. Paul has buried all his siblings. Defendant always knew this. She has always known their vulnerability, and yet she creates a calculated and malicious campaign of disinformation designed to hide the truth in this case. She pits the O'Keefe family versus the Reed family, and a reporter who she asserts editorial control publicly proclaims to Reed supporters the O'Keefe family's period of grief.
Oh, sorry, I was on mute. Listen, Aiden Carney thinks for Aiden Carney. I love this whole like editorial control. Give me a break. Okay. The guy's a journalist. He comes up with his own material. He writes about it. He states the facts. He's not stepping in, giving him editorial control. That is ridiculous. That is ridiculous. He's been writing stories for many, many, many years. He's not going to just come in and say, okay, yeah, just have freedom, editorial control of what I'm writing about. Okay. It doesn't happen. I love all the lies and the bullshit that's being spilt here.
Has expired, and they are now fair game. Discovery will track how much leaked information defendant should have known would result in distress to the O'Keefe family. To the extent that the defendant suggests that this case fits nicely within any other case decided on this issue, remember the facts and circumstances here are exceptional. We wouldn't have these TV cameras or a full courthouse if they weren't exceptional. That is why we are here, Your Honor. It doesn't fit within a nice box like every one of those cases I cite. The Pillay case where we talked about false police reports and harassment petitions were not considered towards emotional distress because they were petitioning activity. I want to talk about that briefly, because what Ms. Reed has done is not petitioning activity. It is not asserting a defense within a courthouse or having her legal counsel assert that defense or testifying at a court hearing. Instead, what Karen Reed is doing is not petitioning at all. She is waiving her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience with editorial control. She's on a Dateline, Nightline, 2020, Fox 25, Boston Magazine, Vanity Fair, WEEI, Turtle Boy, HBO Max, ID Discovery, etc. The
funny thing is she's never been on Aiden's channels. This guy needs to do his homework. She's never been on Aiden's channel. She's never been on, Turtle Boy's channel. That's hilarious.
More.
Editorial control.
This is an exceptional case that requires exceptional discovery, that requires us to decide this matter by a jury, not by a motion to dismiss phase, Your Honor. It is not like the Quinn case that they cite where there's an open adulterer involved, and so they think that's not extreme and outrageous. And it's not extreme and outrageous like it has nothing to do with the employment case where they fired somebody who had a criminal case pending, then they brought them back on, and he didn't like the way that they treated him after he was found not guilty, which is different, by the way, than innocent. The court should deny the third of those arguments. They should know that plaintiff's susceptibility and vulnerability are at issue in this case and are the very reason and foundation why it is extreme and outrageous conduct, and that defendants' improper actions would cause severe emotional distress. Defendants' actions were not rude and clumsy. They were extreme and outrageous. We ask Your Honor to allow this case to go forward with discovery, allow us to explore each and every one of those issues, because these are real damages for real people who have suffered long enough. Thank you.
All right, thank you. Any response from the defense?
Your Honor, briefly. Firstly, those allegations contained in the complaint are allegations which we will refute. Counsel cites to the Camino case, relies heavily on it. What counsel didn't tell the court is that in the Camino case, the father of a child who died in the court.
Becoming a new member. Thanks for supporting my channel. I really appreciate that. If you want to become a member, you can click the join button down below. If you want to support the channel, you can click the link that's attached to the top of the chat that goes to my Venmo or Cash App. My Venmo Cash App's on the bottom. You can also do a super duper duper chat if you want something highlighted. I appreciate you. Thank you so, so much. All right, we got about another 20 minutes or so. We'll hang out here. I want to appreciate everybody for hanging out tonight in the chat. It's been such a great chat. You've all had some great points and a lot of questions. We had some answers tonight. I want to thank all the new subscribers that have come over the last couple of days. We've gained like 1,000 new subscribers on the channel in like the last 3 to 5 days. So that's been pretty awesome. So it's nice to see that. Maybe some people have come back or returned or whatever it may be. But we got a lot of new people. I'm seeing a lot of new names in the chat, which is awesome. And I love all of these questions and Q&A sessions that we've been having in the chat tonight. It's been really productive, and you've all been really part of the stream. So that's awesome. Willow Baby, thank you so much for gifting 5 members. Welcome new members there. And thank Willow for the membership. If you got one, I appreciate that. Thank you. Thank you. Thank you. Thank you. About another 18 to 20 minutes. And we're going to wrap this one up. Let's listen to the opposing argument here.
Car accident was himself hit.
Thank you, Cheryl.
Part of the car accident. Gets up, runs to see his son. It's contemporaneous. It's at the time of the event. And the court didn't have the same spatial, relational, and temporal concerns that the cases speak to with respect to emotional distress claims. So I point that out for the Honor. He also mentioned much about conspiracy theories, much about going out in the public and creating a narrative, which is precisely the reason why we're going to brief the issue about why those other parties need to be in this case. As I'd said, it is more than just a wrongful death action, Your Honor. I respect the opportunity to brief that, and we rely on our papers and defer to the court on the motion to dismiss.
All right, thank you. Any other defendants wish to be heard on the issue? Anything else? All right, thank you. Certainly, there's a lot to the complaint. And again, for the record, so that people understand this, this is a pre-discovery form of relief that the defendants have sought by way of dismissing certain of the counts that are in this complaint. And the court has to consider the allegations as being truthful and every reasonable inference to be drawn in support of that. So I will look forward to reviewing that. I'll issue a decision as soon as I can. As expected, the lawyers in this case have advocated the positions of their clients very clearly, and I expect that with the procedural things that it might be asked for at some point, that this case will have a very long and tail to it as it goes through the litigation process. We expect that in the court system, we give people their ability to try cases and get a jury to listen to the arguments and to ultimately make a decision. My experience in doing this for a very long time in different contexts is that doesn't oftentimes bring the relief that people think it does, and so as a result, there's appellate processes. And so what I envision for the parties, unfortunately in this case, is a very long and sort of complex process that litigation provides. And you know, this is a...
I'll give you my kind of honest answer in this, and I don't think that Karen's ever going to really need to have to speak for anything. She's got great lawyers. She has trust in her lawyers. I don't ever see her getting up on the stand and taking a stand. She doesn't need to. Doesn't need to. Yeah, let the evidence speak to what it is. And that's just my opinion. I don't know. Maybe other people in here disagree with me or agree with me. You can hash it out in the chat. Let us know. What do you think? I don't think Karen's ever going to get up and do any type of testifying. I don't know. So some people say yes. Rosemary says yes, she'll testify. That's what I've heard. She can't plead the fifth. I know Nan's here. She could give us an answer. But you know, again, I'm not too skilled on civil. She'll have to do depositions. I know that. I know she'll have to give a deposition, and that gets used in the civil trials as well too. So, that's, yeah, she'll definitely give a deposition. Yep. Yeah, Sue, thank you so much. I appreciate that. You know, we want transparency. We want to know everything that happened in this case. They were holding that information from us. I found it ridiculous that immediately that these docuseries had access to all of that footage, actually had access to all that footage before the public or journalists could get that. They just like turned it over. It took me almost 7 months of FOIA requests to get that. Nan says she will definitely have to testify. So listen, she's skilled in the law. I'm not. I just gave my opinion about it. She'll definitely be deposed. But Nan's saying that she'll definitely have to testify. So that's where we're at. So Nan says yes. Thank you, Nan. Thank you for that answer and clarifying everything. All right, here, let's go.
Case. It's not a criminal case. There are 8 parties as I identified, and those are the people that the court will be concerned.
I kind of like this part from the judge. Here we go.
With getting a fair trial at some point down the road. As I said, I could do this case. I could do this trial this spring if you'd like to.
Willow.
My sense is that there's nobody that's going to be ready to go to trial by the springtime. If you want me to sign a trial date, we could do so. I mean, literally, I've talked to the clerk. We could do it in March or April if you'd like to. But with the motions that are going to be pending, I suspect that that's not going to be the case, that you'll have to look at this from a more pragmatic point of view and decide when you're going to try to get this thing to a jury. You have a lot of work to do between then and now. I'd like to still get a trial date for you. Now, I don't know what that's going to mean in terms of bringing in other parties. You know, I didn't expect, because the court has had no notice, that there'd be this interest in trying to move this complaint in the direction of other parties who aren't even named in this lawsuit, 10 additional parties. And there's relatively novel theories as I'm hearing it. But nonetheless, we'll let the parties file the motions that they need to, and we'll address them as each comes. But my point in raising this all is that the parties also have another way to do this case. They can do it by way of potential resolution. And I mean this sincerely when I say that being a judge for many years, you learn things. And what you learn is that oftentimes litigation is an inartful way to try to resolve parties' disputes. There's alternative dispute resolution, there's mediation, there's all kinds of other avenues that we advance to try to get people what they want, which is resolution of a case. The most important thing, it would seem to me, to any party to this case, is to resolve the uncertainty, right? Uncertainty is what you don't get when you go through the litigation process. You go through and you hope for the best. Lawyers work really hard for their clients, and we expect them to do that. Ultimately, the court system can make sure that the trial is done, and it's done in a way that's fairest that we can make it. And ultimately, a decision is made. Civil cases, though, are very unlike criminal cases, and that's usually not the end. Ask any of the lawyers here. Clients can ask your lawyers about post-disposition or post-verdict process. It can be really long and arduous. I've had the pleasure of having trials that are 16, 18, 20 years old, and they're still going. The clients don't have to do that. The clients can try.
Hear what the judge is saying here. He's kind of like, hey, we can roll with it, but you might be here 16, 17, 20 years. It's kind of like, all right.
To put some efforts, at least as much effort in the litigation process as trying to resolve it. Why do I say that? Because resolving cases resolves uncertainty, which is perhaps the most important thing any client can get in a case. I say that because you'll have that opportunity through all the process. You've heard me outline it. Your discovery isn't even closing until 2020. The discovery is going to close next December, but it's really 2027 that you're looking for a trial in this case realistically. Again, we could do it in 2026 in the spring if you want.
man.
And I'm going to ask the parties to work collaboratively to try to come up with a trial date that is workable. I understand that's a wrench has been thrown into the works because of this other process. We'll probably have to deal with that in the short term. I'll pledge to try to get you what you can as quickly as I can. I tend to get decisions out pretty quickly. I tend to try to move things to get parties what they want, which is ultimately their day in court. I'm just telling you at the outset that I think that it's worthy of exploring possible resolutions on your own. You can do it through this court. We have a mediation.
Right, you heard it first. Lauren says she doesn't want to come and hang out in my bedroom. So whoever wants to come hang out in my bedroom, let me know. You can come hang out in my bedroom. Lauren doesn't want to hang out in my bedroom. Okay, fine. You want to hang out in my bedroom. I get it.
Process that you can avail yourselves of, judicial settlement conferences. You can go through private neutrals because there are now 8 parties involved in this case, 2 of which are corporate defendants, 1 of which is Ms. Reed. And so that's going to give you a lot of opportunity for dialogue. My sense is I'm probably wasting my time by doing it at this stage of the process, but I think it's important that your clients know that there is an alternative way out of this. Money damages are all the plaintiff can ask for. Nobody can restore, we say this when people lose loved ones or that they have some meaningful part of their body or mind that's been lost in a litigation. We can't restore that. We award money damages. And so ultimately that's what the imperfect litigation system will have. Knowing that, there's a huge opportunity to try to resolve a case like this. And I would urge the parties to have very frank discussions with their lawyers about that and ask yourselves, is it worth going forward with all the uncertainty? And I'm not going to explore with your clients what everybody has to lose. Everyone knows that. If I were representing a plaintiff in this case, I would tell them all about things like the time it takes to get to litigation, how what we have the burden of proof. Yes, it's easier with a burden of proof that's by a more likely than not standard versus a proof beyond a reasonable doubt, but still it's a burden of proof nonetheless. But there's a time value of money. People don't, getting this behind them is an important issue. From the defendant's point of view, again, time is money. There's a lot of time, effort, and anxiety that is put together with a litigation like this. We have 2 ongoing, as far as I understand, the 2 businesses in Canton are ongoing, and they have their business decisions they have to make. Ultimately, they're defendants in this case. They have to understand the risk of going forward in a trial versus resolution. Of course, Ms. Reed herself, a lifetime of potentially facing the uncertainty of a judgment and what that will mean in terms of ability to put this matter behind and going forward. It's going to be very complex. So you can resolve that by looking at putting some effort into this case to resolve it. If you can, great. If not, we stand here committed to giving you the next opportunity to get it before a jury, which I'm suggesting to you could do as soon as this spring, if you want to. Okay. Anything else we need to address this afternoon?
Not from the defendant, Your Honor.
Great. I'll issue a decision on the motion to dismiss. Tracking order stays in place as it is now, but here's my concern, folks. With this motion that the defense team is talking about putting together, I think that needs to be looked at sooner rather than later. It's a big deal, right?
Yes, Your Honor.
Okay. Why don't we get a status date? When do you want to, and we can do by Zoom, folks, if it's just as easy. My order was to have everybody here so that you all get a chance to meet. I want people to be understanding that this is a civil matter, and I want you to be, at least to some extent, trying to be civil about how to resolve your issues. I would have liked to see, for instance, this motion that was brought about in open court should have really been discussed ahead of time so you have a better position on it, but I don't want to waste your time. You want to do next hearing by Zoom? You want to do it in person? You tell me. Plaintiff?
In person.
We're agnostic, Your Honor. I'll do it.
We're agnostic? Is that what you said?
Yeah, as it relates to that, we'll come in person or we'll do it via Zoom.
Defense?
Your Honor, we prefer to be in person.
Okay.
Either way, Your Honor.
They want the fucking cameras on this all the time. They want the world to know. That's why they're saying, nope, we'd rather do it in person. We're going to do it in person. We want everybody to know. Nope. We want everybody to show up. Let's start, taking them and let's start, wasting their time. They want to play ball here. Fine. Fine. Let's just do the same thing they did to Karen for 2 years. If they want to play this game, let's do it. Love it.
All right, we'll do it in person. Fine, we'll do it down here in Plymouth. I will be moving into the Brockton court next month, but this is especially assigned, at least for now, so I'll come back down here. That's not a problem. Mr. Clerk, do you want to suggest a date for us?
Sure. How many days out you want to go? 60 days? 90 days?
Yeah, probably 60 days.
60 days. November 21st, Friday in the end of November.
I'm not too sure. I mean, I've just been kind of spontaneously doing shows right now, just on how I'm feeling and my work schedule. Friday at 2 p.m. I have my appointment, and I'm not going to talk about the details of what's going on. Maybe I will down the road when I get some answers. But you know, most of the major things have been ruled out. So I'll say that. So we're safe in that capacity. But I have some issues going on that, you know, need to be looked at by a specialist, and hopefully we start getting. I'm just more frustrated at this point because it's been going on for 5 weeks, and I thought it was something that, you know, like, oh, okay, this happened, maybe the body will resolve itself, and it hasn't. So it sucks, but I'm not gonna get too intimate into it. But I'm good in that capacity right now. So all major things pretty much have been ruled out. But we'll get some answers, or step towards getting some answers on Friday. I'm just more frustrated at this time because we don't know. And, you know, they'll get some more detailed testing and we'll go from there. So anyway, it just sucks. It just sucks. Sue, thank you for becoming a new member. I appreciate it. I really do appreciate it. All right, let's finish this up about another 5 or 10 minutes or so, and then we'll wrap it up. And I appreciate everybody being here. Lots of new subscribers, members. I appreciate the support. If you haven't, anybody here, if you haven't clicked on that bell notification, please do click on that bell notification so you know that I go live. Another thing that you need to do too, if you haven't, because I know a lot of people don't get the notifications, I post religiously on my channel Facebook page, and you all got to go over there and follow that page. So if you're not getting notifications, go to my Facebook page, LTL Media Inc., click on that, like it, subscribe, however they do it on Facebook, become a member. I post religiously on there and let everybody know when I'm going live. So that's when if you're not getting notifications, click that, get signed up on Facebook, and just check it daily. And I post multiple times a day in there. And I'll post usually like in the morning if I'm going to go live at night. So you'll get your notifications that way. So I want to see 352 new members on my Facebook page tonight. And anybody that's watching this on replay, that way you will get the notifications. So let's see. Lauren says, I understand, Brian. I went through hell last year. Getting my thyroid check took them 3 months to rule out cancer, but you'll be okay. Yeah. Yeah. This has been extremely uncomfortable for me, what I'm going through. It sucks. I don't know what's going on. I'm getting annoyed now because I'm dealing with pain because of this. And Friday, hopefully I'm on the right steps to getting some answers. So, oh, fuck. We'll see what happens. So, Karma says, Brian, you'll be okay. Read the serenity prayer. Give me strength and accept things I cannot change and courage to change things I can. I'm trying to I've been super positive about this. I mean, you can even Lauren, I talk to her a lot. I talk to Nan a lot. I haven't really complained about it. I'm just more concerned. I'm like, okay, I'm concerned. But you know, I've been kind of trooping through it, and Friday's good because they wanted me to wait till November. I'm like, there's no flipping way I'm waiting till November. And then they gave me an October date, middle of October. And I was like, okay, I'll take the appointment. And then my mom used to be in the healthcare field. She called and did some rallying for me. They had a cancellation. She got me the appointment on Friday, which is great. So love you, Mom. You stepped up. You stood up for your baby boy and put your foot down and said, nope, we're going to get him a closer appointment. And I love it. So, all right, let's finish this up.
Yeah, that November 21st. Okay, I'll have a decision out before then, certainly as quickly as I can. 11/21, and that would be for a status regarding tracking order and discovery, and any motions, Rule 15 motions to amend or bring in third parties. Okay, all right, thank you, folks. We'll see you then.
Thank you, Your Honor. Have a nice day.
I thought we had a little bit more.
All right. Nothing with the jury?
I don't think so.
Nothing with the jury?
And you hear the judge there say nothing with the jury. That had nothing to do with this case. As you heard earlier in the hearing, he said we have a jury out right now, so he's probably waiting. Did is there any type of ruling on that jury? So I think that's what we're seeing and hearing here. I know 108. Namaste. All right, we don't need to play out 6 minutes of the rest of that. Let me do this. I'm gonna move my light. I was reading an article, and this is back in June, and you gotta be shitting me. Is this really what this is? So it says Reed will not be deposed until after the criminal trial. It says the court had ruled that Karen Reed did not have to be deposed or questioned in this case until her criminal trial ended. The lawsuit filed in Plymouth Superior Court in Brockton on August 24th is seeking at least $50,000 in damages. Paul O'Keefe, John's brother, is the lead plaintiff in the lawsuit against Reed and the two bars. Also listed as plaintiffs are John O'Keefe's parents and his niece. So you're gonna fucking drag the kids back into it. Fuck. Who's taking care of at the time of the death. So let's use them. Let's use them as a major part of this lawsuit, because they know that everything that they're bringing forth and even dragging these kids into it is frivolous. 50K, at least 50K. We're not going to really know the exact amount. I'd love to know what the exact amount is. I think 50K is the minimum to actually just file a civil trial. And maybe we get an answer here in the chat. Someone's asking Nan a question here. It says, Nan, was that to prevent her from self-incrimination, etc., when she chose to take the fifth? Yeah, I mean, Josie, it just makes sense. You're going to spend a shit ton of money to go through this. And like the judge said, and I don't think it will be, but the judge was saying, like, this could be years. And that's money that you're gonna have to pay all these experts and everything for. So it's like literally you're gonna see what the criminal trial play out in a civil trial. That's wild. They're just gonna have to go through this again. Nan says yes, 50K is the minimum. Seriously, say thanks, Brian. Great show. Wishing you love and prayers. Who's on tonight? Let me see. Is JFK on tonight? They probably are. They always are. I don't see anything on for JFK tonight. Maybe they're off. I was going to bring you guys to oh, no, they are. So they're going at 10:15, and I'll drop their link in the chat before I roll out. That's to go over JFK if you want to watch them tonight at 10:15. Because I know they do the late show. Nan says, yes, she did not testify previous to protect her Fifth Amendment right. She doesn't need those rights anymore as she was acquitted. Aha. Let's see. Yeah, I mean, this is the point. Like, they're going to pay more money on all these fucking lawyers. Good. It's like, good luck. Have fun. If you want to spend all this money, on a frivolous lawsuit that's going to just make you look like a jackass. And I think you're going to lose, and then you're going to be a 3-time loser. You're going to strike out, and you're going to have to go ride the pine. I think that's where we're at. That's at least what I think. Exactly, Karma. It's been factually and scientifically proven that she did not hit John. Let's see. Canine says, sweet. Learning from the best YouTube law. Love it. Thanks. expanding my little world. Love it, love it, love it. All right. Do this. I'm going to head out. I'm tired. That's the link for JFK if you want to go watch them at 10:15. Give JFK, Kevy Kev, James Jackson some love. And I appreciate all my moderators, my members, my subscribers here. I appreciate y'all being here. Nan answering the legal questions tonight in the chat. It was such a great chat, such a relaxing stream to go through this civil trial and give all our thoughts and opinions on it. You know, look, we'll gear up and we'll continue to support Karen in any way we can, talk about the case, have the civil discourse, express our First Amendment rights. I love it. And thank you all for the new subscribers that have come over on the channel. Please make sure to like, share, subscribe, comment down below after the stream, like the stream, subscribe if you're new, turn on all your bell notifications so you know when I go live. And the most important thing, go join my Facebook group. You can look it up, LTL Media, Facebook, LTL Media Inc., or just LTL Media. You'll see my icon up there. Join that group, because if you're not getting my notifications, you will there. Trust me, and you'll know when I go live. So that's it. I will keep you guys updated on health. I'll see what I can come up here with stream in the next couple of days. And we have the Walsh case that's starting on October 20th. I'm going to start gearing up for that. I know my channel is going to do a lot of Walsh content. And what I plan on doing is doing a very in-depth, extended timeline, probably right around October 1st, to start gearing up for that trial, to get you guys informed of things that went on, the evidence, the things that will be argued. I'm ready for it. I want to gear up. I know Nan wanted to take part of that. So I'm sure her and Todd will be on the channel talking about that on our Monday night streams. And Lauren wants to come back and hang out. So we'll have her on the channel, trying to get Mazza over here. And, you know, anybody, JFK, whoever wants to collab and hang out, I'm all for it. You know, hit me up. Let's do some shows together. So go out and support all the channels that you guys watch. I don't know who's on. I know JFK is going at 10:15. So if you want to watch them, the late show, go do that. And it's great to see everybody. Thank you for all the new members that came in tonight and helped out. I'll just go back to that really quick. Let became a new member. Thank you. Beach Life. Look at this 20-month member. Look at this 20-month member. She says, I'm awesome. Willow came a new member tonight too. She gifted 5 memberships. I appreciate that. Sue became a new member. I appreciate that as well. I had a couple of Vemos that came through tonight, so I appreciate that. Thank you for the support. That's it. I love you guys. Kind of a long show for me tonight, but it was very much worth it. Great conversation in the chat tonight. You guys are all rock stars and asked some really kick-ass questions. So, okay. That's going to be it. Lauren says she wants to do an impromptu next time we hang out. So we'll do that. And thank you, moderators. I appreciate you all. I'm going to head out. Guys, have a great night. Make sure to like, share, and subscribe if I can get my outro. That's it. I got to get out of here. Bye.